Welcome everyone to our Thirsty Thursday happy hour. It's actually going to be a Q&A. I am Courtney Roca. I'm the Client Care Coordinator at Legacy Planning Law Group, and I want to thank you for taking the time out of your schedule to join us. Here's your chance to get your questions answered. Joining us today is Bill O'Leary, our attorney and owner of Legacy Planning Law Group. We are a small firm that focuses on estate and elder law. On the screen right now is actually the team, which we like to call Team Legacy. And as you can see, Bill works in an office all with women, so he's adapted very well. He's actually getting ready to have a new member or woman join his family. Tomorrow he will become a grandfather, so congratulations to him. And we thought, what a fitting way to end a long, stressful work week is to have a drink. And whether that be an adult beverage or, you know,
here we go. Can you see it?
An adult beverage, you can go ahead and sit back, relax, sip, and ask your questions, and maybe even stump the expert. So before we get started, I'd like to go over a few of our housekeeping rules. The webinar is being recorded and will last maybe an hour with all of the questions and answers, depending on how many questions you guys have out there. All participant lines will be muted. The questions can be submitted via the GoToWebinar questions box at any time. The recording of this presentation will be sent out to you approximately 72 hours after we conclude. And please participate so that you may have a better experience. As you participate, the better off it is for us and the better off it is for you because you get your questions answered. And at any time, if you're having any technical trouble or you don't see the screen or something's going on, please go ahead and put that in the chat box and I will be there to help. So to get started, I actually wanted to do a poll. Let me get that pulled up. Oh. Well, the poll didn't get put into the webinar properly. So the question was going to be, give me a beer. It's wine time, something strong. H2O is where it's at. So if you could just put in the chat box what you're drinking with us today, we can go ahead and see some of those answers. So I know that Bill has a beer that he will be taking sips of, and I'm going to stick to my non-alcoholic beverage of iced tea. So without further ado, let me go ahead and pass this over to Bill.
Well, thank you, Courtney. Thank you. Good afternoon, everybody. Thanks for joining us. And so I actually was asked a question a few minutes before we got started by somebody who said he would be on. And the question was, is this really going to be like a true happy hour? Are you going to have like an adult beverage? So the answer is yes. So here we go. So cheers to everybody, regardless of what you might be having. Hopefully, whether it's a beer, whether it's an iced tea, lemonade, or whatever. Sit back, relax, and this truly is a Q&A. So you know, ask any question that you'd like. Just try to confine it to this area of the law, which is estates, wills, trusts, probate, that sort of thing. Just don't ask me a criminal law question because I probably have to punt that. So with that, so Courtney's gonna relay the questions to me. If you have a question, as Courtney said, put it in the chat box and try to stump me. And if you do, then you get my respect and admiration. So,
well, before we get started on some of those questions, it looks like we have a couple of answers. Janice is having a beer. Shay is having some scotch and some water. And then Sandra is also having some water. So we do have people that are out there drinking with us. Um, and so let's get on to the questions. Janice asks, do you recommend Ladybird Deeds?
Do I recommend Ladybird Deeds? That's a good question. And so let me go ahead and first explain to others on the call here that may not know what a Ladybird Deed is. So a Ladybird Deed is a special kind of deed to real estate, okay, that makes for the easy passing of that real estate at death without having to be stuck in probate. Now, why do we call it a Ladybird Deed? Well, let me back up. This kind of deed is generically speaking what we call a life estate deed. So it's where if you own, let's say, your house, and you want to pass your house to your son or your daughter or your children, then you would have to take that existing deed that you have of the house that's in your name, and you'd have to execute a new deed, where you would basically be deeding that house to two separate parties. One, you'd be deeding it to yourself, and you'd also be deeding it to your kids. But each of you would have different ownership interests in that house. You would hold what's called a life estate, where you have the right to live in the house for the rest of your life. Your kids then would have what's called a remainder interest. So after you die, they then basically take a title to the property. That's what we call a life estate deed, sort of a standard life estate deed where all you're doing is reserving to yourself a life estate, the right to live in the house. Now, a Ladybird Deed is a special kind of life estate deed. The technical legal term is an enhanced life estate deed, but it's commonly referred to as a Ladybird Deed. No one's really sure where that name comes from. Sort of the popular myth says it was sort of the idea came about when President Lyndon Johnson, for those old enough to remember Lyndon Johnson, his wife was Ladybird Johnson, that he basically came up with the idea of this deed. But from what I have read, that's really not true. It was actually created by some lawyer in Florida back in the early 1980s. He came up with the idea. So it's an enhanced life estate where you, as the owner, are retaining not only the right to live in the house, but also retaining other rights, the right to sell the house and keep the proceeds, retaining the right to put a mortgage on the house, retaining the right to sell the house. So it's almost tantamount to having complete ownership, but not quite. But it's pretty close. Do I recommend Ladybird Deeds? It depends on the circumstance. It depends on the circumstance. And I would tell you it's most commonly done in the context of Medicaid planning. And I don't really have time to get into Medicaid planning. But outside of the context, of Medicaid planning, I am generally not a fan of Ladybird Deeds because although it appears to people to be sort of a quick and dirty solution, and there are people out there that say, you don't need to worry about planning, you don't need to worry about considering maybe a trust to avoid probate, just do a Ladybird Deed. Well, those tend not to be lawyers, to be honest with you, from what I've experienced, and they're not appreciative of the fact that there are problems with Ladybird Deeds. A big one is title insurance companies hate them, absolutely despise Ladybird Deeds. So you might sort of get away with it at the front end as mom or dad entering into this deed with your kids, but then you die, the house may pass to your kids, now your kids want to sell it. There have been horror stories about title insurance problems that have developed. Plus, what happens if your child, as one of the remainder persons, happens to tragically die before you? What's going to happen there? Well, that's going to sort of throw that house into a probate scenario. Or what if your child that you put on as a remainder man they get sued, and now their interest in your house is the subject of a lawsuit that's going to be attached by a creditor. So there are too many downsides to a Ladybird Deed. There are a much better way to accomplish what a Ladybird Deed is designed to accomplish, at least what people think, and that is so it doesn't have to go through probate. But that's a good question. I get that question fairly, fairly often.
Okay. The next question is, if all of my bank accounts have joint ownership and my IRA has beneficiaries, do I need a will? Will I go through probate?
So that's another good question. So, so the question is, okay, I've got a bank account and there's a joint owner on that account. Would that account at your death go through probate? Well, it depends on the kind of joint ownership. Now, please be careful to know that there is not just one type of common ownership. Okay, there is a type of common ownership called what's called a joint tenancy with right of survivorship. You might have heard of that, survivorship. If that's the kind of common ownership that exists, then yes, that would pass to the surviving joint owner. If instead it's not set up with that type of joint ownership, but instead it's what's called a tenancy in common, then the answer is no, it is not going to avoid probate. And with respect to, let's say, the IRA, yes, there's a way to have that avoid probate by designating a beneficiary of that IRA. But when people ask me that question and they're so laser focused on avoiding probate, well, that concern is all well and good. But then the next question is, it's one thing to set forth an easy way for that asset to pass to your loved one. But now, tell me about your loved one. Tell me about, are you at all concerned that that asset may be, subject to maybe their mismanagement? Are they good with money? Or even if they are, do you want to try to protect that inheritance? Protect from whom? Well, the two biggest threats are getting sued and getting a divorce. So if your child gets sued, potentially all of that IRA or joint account will be subject to that lawsuit. Or they get divorced, half of it's gone to the ex-son-in-law or daughter-in-law. So part of sort of giving or getting proper advice is not just looking at a narrow question, it's just how do I avoid probate with this account, but it's considering other issues so that you really do the best by your children. Good question.
The next question I have is from Michael, and it says, what options are there for someone with a large amount of debt that doesn't want to lose all of their assets in probate?
Pay the debt. No, I don't mean to be tongue in cheek. Creditors have every right to be paid before beneficiaries, and you can't get around that. And if you try to distribute money out to beneficiaries too quickly and now a creditor pops up, guess what? That creditor at a minimum is going to go after the executor and ultimately go after the beneficiaries. Now, let's say that you've got a lot of unpaid bills, a lot of debt, mortgage and other debts and so forth, and all of the value of those obligations exceeds the assets that you have, and then you die. Well, there's nothing that would compel your loved one to open up a probate. And we've had this before where, a mom or dad, they've died with a house and the house was underwater. Okay. And so the house is worth less than the unpaid balance on the mortgage. So guess what the kids did? They did nothing. They did nothing. They're not obligated to open that probate because that would have been just a big hassle. At the end of the day, they would have gotten nothing out of it. So in that case, the house was just turned back to the bank. Okay.
Okay. This one's a long one from Sandra, so bear with me. It says, I'm trying to do some financial business on my husband's behalf the other day at our bank, and our bank wouldn't let me do anything because I don't have a power of attorney for my husband. Why would I need a power of attorney for my spouse when we've been married for over 20 years? What extra benefits does a power of attorney even have?
That was Sandra, right?
Yes.
Sandra, very good question. You're not the first person to be puzzled and perplexed by a bank or a financial institution that's not willing to deal with you on behalf of your husband. Well, the fact is that if it's your husband's account, then they're not going to deal with you unless, number one, he has authorized you to speak to them through some internal form that they have, or he has signed a power of attorney. Okay, it'd be different if it was a joint account. I'm sure they would talk to you. So I'm assuming that this is some separate account or separate transaction that you're trying to talk to the bank about. You know, legally, they're not allowed to talk to anybody but the owner of that account. So we actually have run across this on several occasions where it's a couple that's been married not 20 years, but let's say 55 or 60 years, and husband becomes incapacitated, let's say, and now wife needs to manage his affairs, and he never bothered to give wife a power of attorney, so nobody's talking to her, and she's shocked. We've been married 55 years. What do you mean they won't talk to me? And we have to end up going down to court in that case because he's incapacitated. We have to open up a guardianship. A power of attorney is what's known as a durable financial power of attorney, where you appoint someone to make financial decisions for you, okay, in your absence. And in Florida, a power of attorney like that is very helpful, and it actually would allow somebody to make those decisions or engage in those conversations or do those transactions, even if you're not incapacitated. It's effective on day one. So it's always a very good idea for a married couple to have a power of attorney in place where husband has executed a power of attorney appointing wife as the primary agent. You can appoint backup agents, and vice versa. So I think that is sort of a reality, Sandra, that you've faced, and a lesson that you've learned. And so all of that could be solved by getting a good power of attorney in place.
Okay. The next question comes from Angie, and it says, will anyone else in your office be able to discuss my issues if you are absent?
So that's a good question, Angie. And so the answer is yes, yes, to a degree. And so we have a team of 5 here at the office. And so as Courtney showed you, the team, it's a very capable team. They're able to do quite a lot of things, without me, and do it on their own. But if it were to actually come to, giving legal advice, they're not allowed to give legal advice. Now, having said that, they engage in conversations all the time with clients, and it may, seem to the client or prospective client, you're talking about legal stuff. And so the bottom line is there are a lot of things they can do in my absence, but if it boils down to having to give legal advice or write up a legal document, that's something that I would do.
Okay, and then the next question comes from Michael, and it says, does a thrift savings plan have the same rules as an IRA with regards to taxes, such as being able to claim future deposits until April?
Well, Michael, I'm not sure what you mean by being able to claim future deposits, but I can answer the first part of your question, which is yes. A thrift savings plan, think of it as sort of the military version of an IRA, individual retirement account. In both situations, most of these accounts contain pre-tax money. That is, that money was put into the account and it has not been taxed yet. Now you may say, well, that doesn't make any sense because I You know, the money I put into that account, I earned at my job, and I had to pay income tax on those wages or that salary. Yes, you did, but most people then that take that money and put it into that IRA or that TSP are able to claim a tax deduction for that. And so even though they paid taxes on the one hand, they're getting a tax deduction, and so it's a wash. So it's as if no tax has been paid. When the money is eventually pulled out, the tax man will be there and will want to collect their toll charge and be paid at that time. So there are certain kinds of IRAs that have post-tax money in there. That's called a Roth IRA. Some of you may have heard of that. But for the most part, the more common kind of IRA out there is a traditional IRA that has pre-tax money in it.
All right. Gary asks, I have a couple moving out of state. How do the laws affecting trusts vary from state to state?
So that is a good question. Good question. Let me answer it this way, okay? Let's say that the reverse was true. So you've got a couple in another state, and they did let's say a trust in that state, let's say Georgia, you know, South Carolina. Then they move to Florida, and they bring their South Carolina trust with them. The question is Florida going to honor or recognize that South Carolina trust? The answer is yes, if it was put together in South Carolina and it was executed in South Carolina, signed and so forth, according to South Carolina's particular rules governing, you know, when you need witnesses, the kind of witnesses, notaries, all of that stuff. So as long as it satisfies the South Carolina rules, then the answer is yes, it will be honored. I really can't tell you what the case is going in the other direction. It's so moving from Florida to South Carolina, because I'm not a South Carolina an attorney. But having said that, I would have a sort of a high degree of confidence in saying that as long as it was put together in Florida correctly, according to Florida's procedures, that it would be recognized in South Carolina. And the basis for saying that is it goes back to the United States Constitution, and I'm sure you may remember from your civics class, there's a clause in the Constitution called the full faith and credit clause, because we are a collection of 50 states, and so that was put in there to say, look, if a contract is entered into in one state, other states must honor that, must recognize that. And when you think about it, a trust basically is nothing more than a contract. So I would feel fairly comfortable in saying it would be recognized, with the caveat, I don't practice law in South Carolina. Go ask an attorney there.
Okay. Janice asks, my dad's Social Security is $2,680 a month. Does he qualify for Medicaid?
So the answer is no. So let me, by way of background, say that Medicaid is a program that, among other things, will pay for long-term care. Skilled nursing is the most common use of Medicaid, the Medicaid benefit. Well, Medicaid looks at a couple of different things. They look at your health, and they look at your financial situation. So in plain English, you have to be sick and broke. So I won't talk about the health side of things. The financial criteria they look at two elements there: income and assets, So you can't have too much of each. So what if you have too much? Then you don't qualify unless you do some other planning. So on the income side, what is that limit above which is too much? Well, it's a number that changes every year, and it's state specific. But in Florida, effective in 2020, the amount is just a hair over $2,300 a month. So in your case, was it $2,600 a month or so? Then the answer is yes. But does that mean that your father's out of luck? And the answer is no. There's a fairly easy fix if there's excess income, and that is by putting in place a special kind of trust called a qualified income trust, which Basically, the Medicaid law says, even though you make too much money, we're going to still let you qualify for the benefit if you put this trust in place, special kind of trust that meets Medicaid rules, and it serves basically as a receptacle. So throughout the month, the income that's coming into your father from whatever source, okay, ends up being put into this bucket. And at the end of the month, that money goes back out to the facility, except for a certain holdback. For example, a personal needs allowance is allowed in Florida, but most of the money is going to end up going out to the facility. That's called the patient responsibility. Think of it as sort of the, the copay. And then that Medicaid would pay the rest to the facility. So it's a way to ensure the facility is going to get paid the copay from the person that is receiving the benefit.
Okay. Angie asked, how does an estate plan change due to this new Secure Act?
How does the estate plan change due to the Secure Act? So what is the Secure Act? Sort of all the rage in estate planning lawyer circles. So it's a new law that went into effect January 1, and it governs IRAs, retirement accounts. And so it changes some of the rules that we had been using before then. It makes things better for the account owner. It pushes out the date that you have to start taking minimum distributions and make some other changes. So it's actually a good change for the account owner. Who it's not good for are the beneficiaries that are going to inherit that account. Really, it's the kids, the next generation that has the bullseye on their back. Why? Because in the good old days, before January 1, the kids could elect to take the money out of that inherited IRA over a long period of time. In fact, it could be over their remaining life expectancy. That's what we used to euphemistically refer to as the stretch. They would stretch it out over their life expectancy, take smaller amounts out each year, leaving more in the pot to grow and to get bigger. And, the financial advisors can run the numbers. A child taking everything out of a lump sum in the first year versus stretching it out, the net return to them is like night and day. Well, that stretch is gone. The stretch is gone. They can't do that anymore. Now the kids have to take it out by the end of the 10th year after death. So all this basically is a revenue raiser for the government, forcing the kids to take it out over a shorter period of time. Of course, that means a higher tax bill to the kids, more tax being paid to the government. As it relates to the kids, it doesn't really change things necessarily from an estate planning standpoint if the kids are going to be the outright beneficiaries. But if the parent wants to protect that inheritance for the kids, protect it from the kids' creditors, think lawsuit, divorce, then what we do very commonly is set up a trust that will become the beneficiary of that IRA. Instead of the child as a direct beneficiary, we sort of put a trust in the middle, and the trust is the beneficiary of the IRA. The child is the beneficiary of the trust. The Secure Act changes things dramatically in that respect. The kind of trust we used to use before January 1 really does not work for most beneficiaries, most kids. And so we are having to change up the kind of trust that we use so it's optimal for the kids. Good question, though.
Another question is, what makes a trust have to file a tax return?
Okay, what makes a trust have to file a tax return? Well, not every trust has to file a tax return. In fact, most trusts don't have to file a tax return. So if the kind of trust that we're talking about is a trust that people do all the time, what's called a revocable living trust, which is simply an alternative to a last will and testament. If you think about it, what does a will allow you to do? A will allows you to determine who gets your stuff, what they get, when they get it, and how they get it. Okay, who, what, when, and how. A trust answers those same four questions. Same four questions, but in a much better way. because it is a great way to make sure that the kids, for example, don't get stuck in probate. Whereas with a will, then they may very well be stuck in probate. So you don't solve the probate problem by just getting a will. Many people get a trust to solve that problem. So with that kind of trust, let's say that I were to set up a trust for my kids, do I have to file a tax return for that trust? And the answer is no. No. So anything that occurs with that trust, any sort of transactional activity or income that's earned or whatnot, all of that's reported on my personal income tax return. So I still just have the one and only tax return, the one that I have every year, and that includes any activity that occurs within the trust. The only time that you have to file a tax return for a trust is if that trust is no longer a revocable trust, but is what's called an irrevocable trust. In that case, a separate tax return has to be filed. And that kind of trust can be done either while you're alive, or more commonly, it's a trust that you have said, you know, at my death, I want a trust to continue on for my kids, or maybe continue on to for my spouse. I want a trust to continue on after my death. That kind of continuing trust is an irrevocable trust that is a separate tax-paying entity, and that requires a separate tax return. Okay?
Okay, so the last three questions actually pertain to us and our processes, so it's a good segue to the next slide. So I'll ask them in a little out of order, but how long will it take you to complete my estate planning project? Angie asks.
Okay, good question. So what I tell people is that really from start to finish, from the starting point being the time that you decide to move forward to the time that we bring you back for our, we call it our signing ceremony, that cycle is about 5 to 6 weeks, 5 to 6 weeks out. And so so from the time the client makes that commitment to move forward, we actually get that signing date on the books, and then we are all working towards that date. There are times when we can expedite that depending on the circumstances. If somebody's going to go in for surgery or has some other concern, they're going to be going out of the country. But for most people, we operate under that 5 to 6 week turnaround time.
Okay, and it says, will you work with my other advisors, or will you keep the process between the two of us?
Oh, great question. And so I love it when a client is working with an advisor, like a financial advisor, CPA. It's typically a financial advisor. The CPAs really don't tend to want to get that involved because they're so busy with other things. I believe in the team approach and plugging in the advisor as early in the process as possible. And so our process, actually, our planning process, is what we call our family estate and legacy program. And it's just a unique 7-module or 7-step process. Oh, there it is. There it is. It's on the right. And so there at like 7 o'clock, step 5, advisor coordinator. And so as I walk people through in the initial meeting, I walk them through that 7-step process. And it's a nice visual for people to see, you do have a process. Here's the starting point. Here's the ending point, and here's every point in between. And step 5 is the advisor coordinator, where I say, look, I strongly recommend plugging them in because, multiple heads, multiple perspectives and contributions is better than just one, and that can only help the client. So that's our family estate and legacy program here on the right. On the left is a separate process, a unique 7-module process called our estate settlement program. And so this is where somebody has died and their estate has to be settled, whether it's probating their estate, whether they have a trust. So there's some things that have to be done there, usually not nearly as much as a probate. And so I walk the family through. Here are the 7 steps that we have to do. The snapshot meeting is the initial meeting where we sort of understand the family dynamics. We show them how the program works and every step of it. And then there are other modules that we go through. In many circumstances, each of these modules is accompanied by a separate meeting. Sometimes we collapse a couple of them together, so that by the end we get to step 6, we are finally able to distribute the assets out. After we deal with the assets, we deal with creditors, deal with tax issues, we're able to make those distributions out. So I'm a big believer in process, and I am a big believer in showing that process in sort of a snapshot form like this, where they can sort of they can see it all in one place.
And the last question that you can kind of wrap it up with, since it's the last step on the wheel, is do you conduct periodic reviews?
Yes, we do conduct periodic reviews. And so actually, if you look over at the Family, Estate, and Legacy program on the right-hand side, the last step of the 7-step process is called our client care program. And so our clients that are in this program will get an annual meeting. So we will review what's happened over the past year. Have they acquired any new assets that need to be aligned with their plan? Let's say that they have a trust. Has anything changed in their family? Do we need to tweak the trust? You know, has daughter now gotten married, and you know, a son-in-law has tattoos over 90% of his body, and you're not a big fan of him, so you want to protect daughter. So it's a way to constantly stay up to date, to make sure that the plan is up to date and always adapts to changing circumstances. Good question.
And that is the end of the questions.
Okay, all right. So before I turn it back over to you, Courtney, again, I want to thank everybody for taking some time out of your day. Hopefully you were able to sit back and relax, enjoy. I'm very pleased with the turnout, and the questions were outstanding. Unfortunately, I don't know if a question necessarily stumped me. I guess there was a question or two that maybe I didn't fully understand, but keep them coming, and we will be doing this this again sometime soon. So thank you.
All right. Well, thank you everyone for coming. If you'd like to talk to us about your particular situation or whether our estate planning services might help you, feel free to give us a call at the number on the screen, which is 904-880-5554, or go to our website at legacyplanninglawgroup.com. And we are conducting virtual meetings now. Hopefully we'll be able to get back into the office soon enough so you can see all of our smiling faces, and we can shake your hand or fist bump or whatever the new normal will be after all this is said and done. And we have had several virtual meetings already, and they're going smoothly, so please don't be shy or think that during this time there is a reason to shy away. So if you would like to schedule a virtual meeting, those are the 3 ways you can go ahead and schedule those meetings. So thank you, everyone.
Have a great day.